The question is very interesting whether you should have opening statements or so-called plenary in court-connected mediation. My answer is yes, you should, but there are exceptions to that. Typically, a process will involve the mediator making their introductory remarks, followed by opening statements where each of the lawyers provides some argument as to why their case is stronger than the other case and does their advocacy work. Then that's followed by a discussion of the issues and then caucus meetings where the group breaks up and the mediator meets privately with each side. Do we always have opening statements? Sometimes it's contraindicated, and I'll give you two examples. One of which is employment cases. I don't remember the last time that the lawyers, both defense counsel will represent the employer and plaintiff's counsel, who typically represent the employee, wanted to have opening statements because they are emotional in nature. It sounds funny to say that because typically you're arguing only about money, but I always say this to people when I'm doing workplace mediations: you spend more time at work than you do at home. So there's an employment case emotional component that can be made worse by aggressive openings. So typically we avoid them in those cases. And the same is true of estate litigation. I find that in a lot of those estate litigation cases, for example, siblings fighting over what dad really meant to do with his will or whether he should have changed the will and made Johnny, ne'er-do-well son, his executor and gave him half of the estate or the entire estate, it's usually very counterproductive to have openings because it can devolve into a very ugly kind of emotional scene. So lawyers typically ask me, and I tend to agree, to avoid the openings in those cases. But more often than not, I like to have openings because I think it's important for the parties and the lawyers to speak directly to each other as much as possible.